This is what we're here to talk about, the collaborative practice model. What is it? How is it different from mediation, and where has it been used? So the collaborative practice model is a creative problem solving in a team environment. It's helping clients find solutions beyond the application of legal rights and entitlements. It's an interest-based and it's focused on clients' beliefs, goals and values. It was started by Stu Webb in about 1990 in the USA. And it's also practiced in the UK and other parts of Europe since 2003, and now the IACP, which is the International Association of Collaborative Practitioners, has about 4,000 members worldwide. How it's different from mediation, it's practiced with a framework that's essentially a contract that we'll talk about in a moment, that is a contract between clients and their lawyers and other independent parties that will provide value to the team, such as an independent financial advisor and an independent communications person who might be a grief counsellor, might be a psychologist or someone else that can help with the communication. It's not done late stage, it's done early, and it's done with a view to staying out of court.
Sorry to interrupt. No. I think that's the fundamental difference about thinking like a positive problem solver, like a collaborative practitioner, that it starts the moment you first meet your client, that the message you send to them in the very first consultation is that we are going to sit at a table like civilised people and work this out, that you're the one whose interests matter most and my job is to work out how we progress that. If you start a process like you've always done and give the advice that you've always done, excuse me, and polarise early, like we historically, if we're practising traditionally do, you invite a change of gear once you've already pushed everyone to the extreme. This process invites you to cut that off before it even begins.
I think we'd probably all agree that most of our experiences of mediation in a contested estates context is often one where we go in with an expert mediator and we're in a shuttle so that we're separated into rooms, and it's often done after the damage of the grenades of correspondence going backwards and forwards or perhaps even affidavits have been exchanged. So this is a little different because we're talking about doing this very, very early, perhaps even without correspondence. Imagine that, not having to write those 8-page letters. Being able to have a conversation. So sometimes it's a lot more to do with talking than it is with writing. We still provide advice for our client, and we have to learn to trust our opposition or the persons that are representing the other people.
It's absolutely essential to understand that this is not a therapeutic process. If you're a true law nerd like me, you'll understand that it's grounded in therapeutic jurisprudence, but it's a legal process. The end result is a binding legal document. The framework that we operate in obviously has to fit within whatever your jurisdictional requirements are, but how you get to that result and how you might document it, and there are always ways of dealing with issues that might be legally contentious, is what is so fundamentally different. Family lawyers, when we began practicing in the early years in this sphere, were often accused of going into rooms with our clients holding hands and singing Kumbaya, or that collaborative lawyers were not smart lawyers. It is the hardest work I do. I have to be an excellent lawyer. I have to know when to put my foot on the gas and when to take it off. And I have to be at my very human best. I don't mean to suggest that lawyers aren't humans, but I have to be watching and listening for and processing so many other things to make sure that I don't revert to type, even 15 years down the track, and expand the problem because I like to be right. Because it is the linchpin of this process. And essentially what it says is that we will not threaten to go to court or go to court. We, the lawyers, are as bound by this contract as the parties, and we are committed to using every means possible other than litigation to solve this problem. And we are committed to the rules of engagement, if you like. The last page of that contract, I would encourage you to have a really close look at. It sets out the way we're going to behave in the process. And I always say to my clients, it's really the how not to be a dickhead list. And it is more for the lawyers than it is for the parties, because it is. It's about speaking openly, not withholding information, not using mistakes against the other, taking ownership of the things that, and this is more about the parties, that you feel and want and that drive you, and being honest about them, allowing everyone to work out what actually is the roadblock rather than being vague about it, about exchanging information as just that. It's just information. It's not weaponry. It's the keys to the puzzle to work out how you come out the other side. The medical analogy is like saying it's two doctors trying to keep the patient alive rather than hacking off a limb each as fast as possible.